Vodanovic and I'm a housing and property law practitioner at Trinity. And today I'm talking to you about the Court of Protection and what role that can play at times in housing law cases. If you're not already familiar with the work that the Court of Protection does, then the first thing to note about it is that it's entirely the creation of the Mental Capacity Act 2005. And as a result, it deals entirely with those who lack mental capacity. The scope of what the Court of Protection deals with is much wider than the ambit of this talk, or the remit of this talk. But I want to look at a limited number of circumstances where it might be relevant to housing law cases. And even though it's limited in having that relevance to housing law, it's nevertheless important and something to think about. So in order to understand how it might be relevant, I'll take you through the jurisdiction and the powers that the Court of Protection has, and then how those powers might be of assistance in the housing law context might become clearer. And I'll then look very briefly at the process that's the process of applying to the Court of Protection for an order. So as already mentioned, it's part 2 of the Mental Capacity Act, which gives the court its jurisdiction. All its powers are contained within the Act itself. The court has its own procedural rules. The judges authorised to sit in the Court of Protection are the same district judges and circuit judges you're going to come across, but they just have a special COP ticket. And for more complex matters, you can come across High Court judges. So the powers, as you will see, can end up having quite wide-reaching consequences in terms of permeating many aspects of a person's life whenever a decision needs to be made on their behalf, including life-sustaining treatment, other medical treatment, etc. But obviously I'm only looking at the housing law context. So the first issue that the Court of Protection has to determine, if the powers are to be engaged, is if a person does indeed lack mental capacity. Often that might not be contentious, but equally as often it is. And capacity within the context of what the Court of Appeal has to deal with is not just capacity to conduct litigation, which is what we come across in the context of the county court. Capacity generally under the Mental Capacity Act is issue-specific and time-specific. And it's about whether a person is able to make a decision for himself. We'll come to that in a moment in a bit more detail. In relation to the matter, so use of the word matter is a wide and ambiguous term, because of an impairment of or a disturbance in the functioning of the mind or brain. So obviously evidence will be needed from a professional who's able to give an opinion on this. And then the rest of section 2 goes on to say, as you'll see in your handouts, because I've set it out, that it doesn't matter if the lack of capacity is permanent or temporary, and the Court of Protection will determine this particular issue on a balance of probabilities. So returning to, or moving on to look at more detail, what does it mean unable to make a decision for himself? Well, section 3 tells us exactly what that is. It's looking at whether the person can understand the information, retain it, use or weigh it, or, important or there, communicate his decision. So that's the 4-stage test. And that or at the end of subsection C will tell you that if a person's unable to do any of those, then they are likely to be deemed to be unable to make a decision. Subsection 2 of subsection 3 in your handouts on page 48 will tell you that there has to be an attempt at presenting the information in a way which is appropriate to the person's circumstances. So before you reach the decision whether they've got capacity or not, or before the court does, there has to be an attempt at trying to use simple language, visual aids, or any other means to try and get that person to understand and weigh up the information and so on. So whenever the Court of Protection has to make these decisions, it has to abide by the overarching principles, which are set out in section 1 of the Mental Capacity Act. And Pretty self-explanatory there. There's a presumption of capacity unless it's shown otherwise. All practicable steps to help the person make the decision have to be taken first and have to be unsuccessful before you move on to the next stage. Unwise decisions are discounted from consideration. There's the best interest concept introduced. We'll come and look at that in a moment. And then there's this principle of trying to choose the least restrictive way of going about trying to make the decision for that person. Section 4 has said the best interests. They're set out. They're pretty self-explanatory. None of them are surprising. Don't make assumptions. Consider all the circumstances. Encourage participation. Consider the person's wishes, beliefs, feelings, values, any other factors that they would consider themselves if they were able to. And then consult others. And others is anyone who has an interest in that person's welfare, well-being. So those 4 sections that I've just rattled through are effectively the crux of the Mental Capacity Act. That's what it's all about. And that's how the Court of Protection operates in the light of those principles set out there. But the more interesting thing, obviously, is what powers does the Court of Protection have? What orders can it make? The first one is contained in Section 15, and the Court can make declarations. As I said earlier, the very issue of capacity can often be contentious. So a declaration about that particular issue, whether someone lacks it or not, could be all that's needed. And then everything else will fall into place with whoever they're dealing with. And the Court of Protection might not be asked to make any other decisions about anything else, save for that declaration. They could be asked to make a declaration about a capacity about one particular thing, such as, do they have capacity to consent to that particular medical treatment? Yes or no? Could it be a more general issue? Do they have capacity to decide on their finances, for example? So it could be specific to that. Or could it be a declaration about the lawfulness of something that was done or is about to be done? If something was unlawful because a person lacked capacity, that could then trigger satellite litigation against other public bodies under various other causes of action. But the Court of Protection's involvement doesn't continue at that stage, obviously. Or it could be a declaration about something that's to be done. And if the declaration is that it is going to be unlawful, then hopefully that's with the aim of preventing it from happening. So that deals with declarations of, say, Section 15. More specific powers then come in Section 16, and in relation to 2 matters, A and B there. We'll come on to those in a minute. But in terms of the orders that can be made, the Court of Protection can make the decision on behalf of the person lacking capacity and order something to be done. It can make the decision as to what it wants to happen, but authorize someone else to do it or to take certain steps. Or lastly, a deputy can be appointed to deal with certain matters, as wide-ranging or as limited as the court wants to make it, and then the deputy makes the decisions. So personal welfare and property and affairs are what Section 16 is about, and there's further guidance in Section 17 as to what Section 16 powers in relation to personal welfare contain. There's a long list of them. I've set them all out in the handout, but I've highlighted those that might be of interest to us as housing practitioners. Key one, subparagraph A, deciding where P is to live. B and C are also relevant, deciding what contact, if any, P is to have with any specified persons, and making an order prohibiting a named person from having contact with P. So this can all be very relevant in the housing context. The rest are not that relevant, which is why I skip over them. So that's personal welfare. Section 18 defines what property and affairs is. The first bits of it are all to do with effectively ownership of property, which won't concern us in the present context. But then F and G are quite relevant. The carrying out of any contract entered into by the person lacking capacity. Tenancy agreement is a contract. The discharge of P's debts and of any of P's obligations, whether legally enforceable or not. So a tenant will have obligations continuing under the tenancy agreement. And then obviously the last one, the conduct of legal proceedings in P's name or in P's behalf, but in the context of the Court of Protection. Having looked at those then, you can see where there might be some relevance in the housing law context. So what about examples, and where could this be relevant? Someone lacking capacity can't sign a tenancy agreement. Someone else needs to sign it for them. The next of kin can't do it. Family friend can't do it. The social or support worker, can't do it. The housing officer certainly can't do it. So how is that dealt with? Well, an application to the Court of Protection can be made. The Court of Protection can authorize someone else to sign the tenancy agreement, and they are then legally entitled to sign that tenancy agreement. If you've got a situation where the tenancy agreement has already been signed, the issue of capacity only arises later, that tenant wants to end the tenancy, there's a notice to quit. If they lack capacity, they can't serve the notice to quit either. So the Court of Protection, again, can authorize someone else to serve the notice on the tenant's behalf. So that's to do with signing or ending tenancy agreements. What about continuing to comply with the tenancy agreement obligations? Because ultimately, whoever signed it, the person lacking capacity is still in the property, living there, and they have to abide by the terms of the tenancy agreement. Well, with the payment of rent as an obligation under the tenancy, it's unlikely to be a massive issue in the housing law context because of benefits. If you're on benefits, you can apply to the DWP directly to have an appointee. You don't need to go through the Court of Protection. If there's private money involved, then you would need to go to the Court of Protection to get somebody to be able to pay the rent on the tenant's behalf. And the Court of Protection could deal with just that one issue if that's all that's required. What about the condition of the property? Well, that can be dealt with by asking the Court of Protection to make certain orders that various agencies should do X, Y, and Z, or that other persons should do X, Y, and Z to bring about compliance with the condition of the property. I mention hoarder cases there specifically because they're a common subject matter in the Court of Protection. They are complex. A lot of work is required to bring about compliance in relation to those cases, so the court's input is very often required. In the handout, I've given you a reference to a case, page 54. And this is AC and GC. It's a Court of Protection case. It's a very good example of how the Court of Protection dealt with the various principles that I've just discussed, sections 1 to 4, and then the powers as well. But it also then considered various options available to it. What it did, this was an elderly mother and a son. The son was the hoarder. They removed both from the property by way of an order. Another order dealt with cleaning up the property, getting it safe from or preventing the hazards posed by hoarding. And then another order meant that they could go back into the property on a trial period to see how the son effectively did and with the mother in situ. So different orders made by the Court of Protection, all to deal with that very issue, to prevent the problem from continuing. So it's a useful one to read if you're interested to know a little bit more about that. And then what about antisocial behaviour? That can often be perpetrated by others who seek to take advantage, perhaps, of the person lacking capacity. I'm sure you've all come across those cases. An injunction against the perpetrator is often an option, but it might not be for various reasons. Sometimes there might be too many people involved to try and get an injunction against all of them. You might not know who they are. Remember those two things back in section 17 that we looked at? Deciding what contact, if any, P is to have with any specified persons, and making an order prohibiting a named person from having contact with P. So there's sort of injunction style means of dealing with the problem, but they're not an injunction. They're an order of the Court of Protection. So it's something to bear in mind, whether you're going to come across the same issues of enforcement against those persons as you would in injunctions. It is a big query or a big worry, because enforcement is done by way of a committal application to the Court of Protection. So you have to then consider whether you've got prospects of succeeding there, and then who are you actually enforcing against is a question. Who's responsible for it? So there are issues with perhaps adopting that approach when it comes to antisocial behaviour. The other things that I described are perhaps easier to deal with. But what I would say is, given what we've looked at in terms of the powers, I think there's probably more scope for creativity in terms of the types of conditions that you might get from the Court of Protection than you might get in the county court in your bog standard possession proceedings or injunction proceedings. So it's something to bear in mind. And then lastly, the court can make a decision on where a person is to live. For example, if you have a local authority or a social landlord who decides that the problem in this property with this particular tenant who lacks capacity is best resolved by moving that tenant to another property. It's in their best interest. You remove them from the bad influence area, you bringing them closer to other support that they might have, but the tenant doesn't want to move for whatever reason. Hoarder cases, tenants often don't want to move. You might have a litigation friend, if you've already started proceedings and this is happening during proceedings, litigation friend is not consenting to the move either. In those circumstances, the best way of dealing with it is to let the Court of Protection perhaps make the decision for them and get them to move, and accept the alternative offer accommodation and authorise someone else to sign the new tenancy agreement. Mentioning then this can happen if you don't have possession proceedings afoot, but if you've got possession proceedings afoot, which is not uncommon, and the issue of capacity only arises after issue of proceedings, which has been raised at the defence point, so the tenant is lacking capacity, the county court can make an immediate possession order, can't they, in those circumstances, because they can say, well, the best thing here, there's been an offer of alternative accommodation, we've got these possession proceedings, the only way to force this tenant out of this property and make them accept the offer of alternative accommodation will make an immediate possession order. But that's where the county court's powers stop, don't they? You can't make the tenant accept the alternative accommodation. You can't make them sign a tenancy agreement. You can't make the litigation friend sign the tenancy agreement. That's where you need the Court of Protection to come in. What you can do is you can make concurrent applications to the Court of Protection during your county court proceedings for possession, and then one will inform the other. I think Gary was telling me the other day, you had a case where the same judge, who was sitting as a district judge in the county court, also had a cop ticket and just dealt with it with concurrent proceedings effectively. Yeah. So these are just some examples that come to mind. There will be others, but it's something to think about as another avenue of a resolution to the problem that you're presented with. What considerations then apply before steps are taken to make an application? Well, somebody's got to come to a decision or come to a view that this person lacks capacity if it's not clear. Housing officers dealing with tenancy management will have to make this assessment. And they'll have to make the assessment whether to accept the signature from this person as a valid signature for a legally binding tenancy agreement, or can they accept the notice to quit from this person? And they'll have to look at the 4-stage test that we looked at in section 3, understanding the information, retaining it, weighing it up, etc. And then concluding, are they able to make that decision for themselves? So this is quite an onerous task for housing officers when presented with persons where it's not clear whether they lack mental capacity. And then it raises a number of points about what those housing officers need to do about the process, record keeping, etc. But I'll leave that to one side for the purposes of this talk. If it is clear, though, that the tenant does lack capacity, then there need to be questions asked. Is there anyone else who can actually sign the tenancy agreement legally? That somebody else could be an attorney under a registered lasting power of attorney or enduring power of attorney, or there might already be a deputy appointed in respect of that person in relation to general matters to do with property and affairs, in which case they should be able to sign the tenancy agreement. But if there isn't anyone who can legally sign it, then the chances are an application will have to be made by someone to the Court of Protection. Otherwise, if you're dealing with anything else other than the signing of the tenancy agreement, the main issue to consider really is whether it's a one-off decision that needs to be made by the Court of Protection or a series of one-off decisions that are easily discernible, or does there need to be a deputy application? And remember, the deputy is authorised by the Court of Protection to make decisions on a specific matter or more general matters. So it depends on how extensive the issues are, and you need to, or the person applying needs to work out what it is that they want to apply for. But the Court of Protection will avoid appointing a deputy if it can, because that's the more restrictive option. The Court of Protection will want to choose the least restrictive option that's available to it. And then lastly, who can apply? If this is the process that needs to be gone down, you need to make an application to the Court of Protection, or someone needs to, who can that person be? Well, anyone can apply to the Court of Protection, but the chances are it's not going to be just anyone. It will most likely be a family member, close friend, or a professional. And that professional could be a solicitor, official solicitor. Very often, though, it's going to be social services who take this step. So for the local authority housing departments in this room, that might be easier to navigate, perhaps, and ensure cooperation from social services. For the rest of the social landlords, a little bit more difficult, perhaps, to get the cooperation from social services if required. How do you make the application? It's a prescriptive process. There are online forms, specific procedure is set out there. There are guidance notes. There is a fee payable, which sometimes makes it tricky for family members, perhaps, to commit to making that application. A number of forms exist. They're in your handout. I've listed the most relevant ones that might arise. And again, it will all depend on what is it that you're applying for, and that will determine which form you should use. And then there are some generic forms, such as COP3 is the assessment of capacity filled out by a professional, and COP24 form is a witness statement in support. What I would say lastly, if you are in doubt or you wanted to learn more about it, or you're signposting someone to finding out more about the process, then the Court of Protection Handbook is online. That's extremely helpful, and that's probably your first port of call to understanding how the process works.